I'm gonna stop screen sharing so that you can start.
Okay.
Y'all bear with. Okay, I think I have stopped.
Okay. I'm
You
gonna.
able-
Yeah.
Okay. Okay.
You off?
I think I'm off, and I think you can now share.
Okay. It's not letting me on. It says other participant is shared.
Oh, hold on just a second.
Oh, okay.
I thought I had stopped.
Okay.
Y'all bear with us because not only are we having to work with technology, we're working with brand new shiny technology. It's a little complicated though. Just bear with us for just a moment. Okay, Flint, are you now able to share?
Yeah. Yes,
Okay.
I am.
Thank you. All right, we'll take it away. Thank you for being here with us today. We appreciate you for.
You bet. Just give me a minute to. Can you see me?
Yes. Hi,
Okay.
we can see Mr. Wilson from Home Improvement. We can see the nose up.
Okay. Well, okay, you ready?
Yes.
Well, good morning, everybody. My name is Flint Smith. As Amber said, we've been friends a long time. I have lived here all my life. I've been a school psychologist for 29 years, and I'm looking forward to speaking to you this morning. It's an honor to speak to you. I've been on kind of doing my own thing the last year or so, and I'll talk about that at the end. But this morning, we're going to talk about two landmark cases that have defined fate for us. If you've ever been to LRP or had any legal training, you've heard probably of both of them. So in just a minute here, I'm going to pull my PowerPoint up and we'll get started. And I know there's a chat process there to ask questions. And you know, this is an unprecedented time for special ed and for the whole country and education as we get ready to launch a school year like we've never launched. It's amazing when you think about it. And when you think about the process of developing IEPs and delivering services, you know, I've talked to many parents recently. There's a lot of anxiety about their child getting their services and, you know, continuing to make progress. So I'm going to pull up my PowerPoint and we'll get started. Give me just a second. Okay. Since I can't hear you, I'm assuming that you can all hear me. So we're going to get started here with the impact of Endrew and Raleigh. One more thing here, I got to get going here. Okay. All right, so give me just 30 seconds here. Okay, I'm back. All right, so a little disclaimer, I'm not an attorney, but I do hang out with lots of attorneys. So, you know, I'm not one, so I'm not giving legal advice today, but I have worked with a lot of attorneys at the district level, state level, and presented with some of them and have learned a great deal from them. I continue to get several hours of legal training every year. So we're going to get started here. And if you have any questions, go through the process that's on the screen that where you can ask questions. They may have to text me or buzz me to let me know because I can only see my PowerPoint right now. Okay, so let's get started with guiding principle one. And that is that IEPs are procedural in nature. And most errors that we make that result in litigation across the country, whether a school system or a parent, which is usually what happens. Most of those are the result of procedural errors. What's the difference between procedural and practice errors? Well, procedural errors are those things that we're going to talk about here in a second that are foundational principles under IDEA. So what's an example of that? Well, not letting the parent participate enough, not following due process, not communicating with parents, not developing an IEP that, completely explains the child. What's a practice error? Practice errors usually happen with people like me and psychologists and ed diagnosticians, speech pathologists that are actually doing the evaluation, not using the right tests, not interpreting it right. Practice errors are not as common, but they do happen. But what really will get you in trouble is substantive procedural errors. And okay. So all you can, procedural errors are the ones that you have to really pay attention to. So the guiding principle, we're going to be talking about FAPE today. And so let's talk a little bit about some of those errors, because these two lawsuits we're going to talk about today have to do a lot with IEPs. But these are the errors that predominantly occur that would be considered substantive. So child find evaluation. Anybody ever had a complaint that you're not picking up cases, you're not screening child find? IEP content, are there conflicts over the actual IEP, which is really what led to Rowley, what started all the FAPE types of lawsuits. Implementation, let's just say we get a good IEP written and there's disagreement on how it's implemented. That was a problem with Rowley and Endrew. And then the last two, believe it or not, these are all interconnected except for child find. Ineffective collaboration. That's something that administrative law judges are really starting to look at over the last several years, especially since IDEA has been reauthorized and rewritten. Are you effectively collaborating with each other and with parents? And of course, the last one is something we dealt with for the entire history of developing IEPs. So I'm assuming most of you know the history of special ed, some of you don't. We'll give a brief overview here in a minute. So what happened on these two cases? Parents disagreed with the school. They said, you're making errors. I don't like the content. I don't like the way you're implementing it, or I want other services, and I don't feel like you're working with me. Short story. Okay, let's go to the next screen. So I always like to do this because I don't expect you to memorize this today, but these are the basic foundational principles of IDEA. Zero reject means everybody, right? FAPE, now the problem with free, appropriate public education, we get the free and the public, and it's education, right, but appropriate is where we disagree, right? All kids have a right to an individualized education plan, as you know, once they're identified. Number 4, non-discriminatory evaluation. Big deal in early history of special ed. Using the wrong test, not in the kid's native language. Are we dealing with that now with ESL students? We are. Least restrictive environment. That is the heart. That and FAPE are the heart of an IEP, right? Number 6, procedural due process. This is one that we really have to watch. We have to notify parents, give them time, all the state requirements and federal requirements to stay in line procedurally. And like I said at the beginning, that will get you in trouble quicker than a practice mistake most of the time. Procedural errors. Why? Because they lead to bad IEPs. Good procedure, good IEPs. Good place to start. Number 7 and 8 are newer under IDEA. This was not around when Public Law 142 was passed in the mid-70s. The 7 and 8 are so important. These are foundational principles of IDEA, and they drive everything that we do, from referral, screening, referral, to IEP, to reeval. It's all right here. So sometimes I'll come back to this screen when I'm talking about that. I will refer back to one of these foundational principles as I go through here. So let's talk about guiding principle 2. I have 2 guiding principles. The first one is the errors, procedural errors tend to lead to litigation. And number 2 is federal law supersedes state law. Now, does this create a conflict for you sometimes? You betcha. I was a psychologist in the public school system for 29 years, and without a doubt, we can pass local, state, even state criteria sometimes is in conflict, sometimes with federal law. One of the areas you see that is discipline. I don't know how many discipline legal conferences I've been to where they talk about 10 days is 10 days. Well, some states, 10 days is 10 days. Other states, they interpret it a pattern of discipline. So I've seen that conflict. What about if someone says all kids that are mild, cognitively impaired, intellectual disabilities, they only get 1 hour of they only get 1 hour of services. That's not really individualized, right? So when you read the federal law, which these 2 lawsuits are federal, and if you get to an administrative law judge, these are the 2 they're going to look at in terms of, does the IEP have validity? Is it what the kid needs? As my good lawyer friend always says, when he gets down past all the legalese, he'll go, what does the child need? Well, who determines that? The IEP with the parent and whoever else they bring with them sometimes, right? So these were rulings by the U.S. Supreme Court. Both of them made it all the way to the court. And let me get back to it. Sorry about that, going a little too fast. So now, the problem with sometimes when you work in a local district, which most of us do, or at the state level, you will find there are some things that are not exactly interpreted like the federal law. And if somebody wants to, and they're committed to it, they can take it all to the Supreme Court. That's what happened on both of these cases. Now, before I get started, we're going to talk about Rowley first. It's very important that we understand the background of both of these children, because both of these children that precipitated these cases had very different programming, and also they were 35 years apart almost. So, what we did in the early 80s and what we offer now, radically different. However, the FAPE standard was the same. That's what they were looking at. Did you provide FAPE? Well, is FAPE a static process or is it fluid? Well, if you look at some IEPs, you'll see that it's static. But we all know as children change, their IEPs have to change, right? And sometimes that happens, sometimes it doesn't. Rowley's parents, Amy Rowley, did not feel like it was changing. Nor did Endrew. So remember, procedure's everything. And federal law trumps state law. Okay, so let's talk about Rowley first. I'm going to go through several screens pretty quickly here and talk about Amy. But she was a hearing impaired student who was fully included, and she was identified under IDEA. It wasn't called that then. It was just called A lot of people just called it 94-142, but it wasn't called IDEA yet. As we know, that didn't happen until the 90s. But she was under the special ed law, and she was identified with hearing impairment and deaf in New York. Now, a couple other things about this case. Prior to the beginning of her kindergarten year, her parents, who themselves were deaf, met with the school administrators. A couple of background things. It's interesting. Her mother went to Gallaudet in Washington, so she understood the history of special ed. They were pretty well versed on it, and I'm sure they had an attorney at some point here when it got past the district level and the state level. But anyway, both of her parents probably missed out on special ed intervention in their primary school experiences. But from what I've read, they both knew a lot about it, and she went to Gallaudet, so she was very informed about special ed law. And one of the things that a lot of people don't remember is there was a special ed law passed in 1970. It was good, but it had little teeth because there was no funding. When Public Law 94-142 was passed, it was like all bets are off. We're going to give you money, and now there's no excuses. You got to do it. We're going to identify kids. We're going to give you money to educate them. All bets are off. And wow, that was groundbreaking. So just remember, this Rowley case is only about 6 or 7 years after that. So we're still in our infancy in understanding how to develop IEPs and implement them in a public school setting. So this was new. So parents, if you look at the screen, they met with administrators, and I do a lot of training for administrators I have done over the years, principals meetings, talking about how dynamic IEPs are, how they change. So let's look at this. So they met with the administrator, and they wanted to do an IEP, and they wanted a sign language interpreter in the classroom. Do we get that request today? Of course we do, among other things. So what happened? This is important right here. Even though Amy's academic performance was better than average, meaning what? Meaning she was making good grades, and she had advanced from grade to grade. She understood considerably less in class than if she were not deaf. And the parents' argument was she was not meeting her full potential. Again, this was 35 years ago. Actually, a little more than that when it was being fought out in court. So they said, here's what we want. Anybody been in that meeting lately? And you can request anything you want in an IEP, right? So before I go any further, just for FYI, we can't respond in like a normal training here, but I always tell people that I ask them when I do one of these trainings, what's the longest IEP you've ever had? And I can't hear you right now, but the longest one I've had was 3 days. I know a friend of mine had a week IEP one time. I had 6 IEPs with one student in 3 months in an alternative setting. So we can't get in our minds. We make mistakes procedurally when we say, well, you got an IEP, we're not having another IEP for 12 months. That's not what federal law says. Someone can ask for an IEP anytime they want. People hate it when I say that publicly sometimes, but that is the truth. And it does cost more work for everybody, but it is also what the law says. So this idea that an IEP is static and here's what you get for the year is not federally correct. It may be something we like to do locally and even state-wise, but it's not federally correct. And that's what I meant when I say federal law supersedes state law. And when will you find that out? When you go to an administrative law judge. He's going to look at the Supreme Court case. And that's the two we're going to talk about. You can say, well, it don't matter if they don't do that, but that's true. But Endrew is only 3 years old, and it's starting to take effect in school systems. And when we end this, hopefully you'll have a better understanding of that. And I'm still learning it too. So back to Rowley. Parents said she's not meeting her full potential. So here's what we want. Following a 2-week trial period, after the interpreter was in the classroom, they did give them an interpreter. The interpreter said, she doesn't need my services. So for the remainder of the school year, they replaced it with an FM wireless hearing aid, and we still do that now, FM systems, which I like. My wife was a hearing impaired teacher for 33 years, and we found they help just about every kid in the classroom. Not just kids on the spectrum or hearing impaired kids, but kids with ADHD and attention problems. So this is kind of very, very far thinking. This was in the early 80s, and they were using these. So they replaced it. But what happened then? Well, at the beginning of the next year, a new IEP for Riley was prepared as required by public law. And she was again given an FM wireless hearing aid. Now, again, understand that both of her parents are legally deaf. Additionally, she was to receive instruction from a tutor for 1 hour and given speech therapy for 3 hours a week. Now, they offered a lot, right? So remember that. It's important in the outcome of this case at this time with the Supreme Court. So let's go back. They pulled the interpreter, but they gave her an FM system and a tutor and speech therapy. That's a good bit, especially for the time. All right, so what happens next? Parents said, not good enough. I want the school to provide a sign language interpreter. And if you go back and read the docket, which is huge, they asked for this several times. Instead of other forms of assistance identified in the IEP. All the stuff we just talked about on the last screen was in the IEP. They took sign language interpreter out. Basically, what do we have here? Parents go, I know she's making progress, but she's not meeting her full potential. So this is a big argument about IEPs and public service. How many of you have heard in your practice? If you're a parent, you may have even heard this, but there's this idea, this philosophy that because it's public, we don't have to offer the top shelf. We only have to do the basic. And that's what Riley was about. And so it's interesting to see what happened between 35 years between Riley. The parents are going, that's fine, she is making progress, but we want her to meet her full potential, as most parents do, correct? And so that's where we're at. So here's what they asked for. And here's what they said. School administrators refused the request. And of course, I'm simplifying this, but I'm sure they met with the special ed director and several other people. So Riley said, okay, then we're going to do administrative review. They appealed to the state under the state guidelines and the federal guidelines, and continued to argue that with a hearing aid, but without an interpreter, Riley would only be able to understand about 60% of the spoken language in the classroom. So they're getting their argument a lot more specific here, right? Where did they get the 60% from? An independent examiner agreed with the school that an interpreter was unnecessary, a decision that was affirmed on appeal by the New York commissioner. But what I don't have in here is they had a private evaluation. Let's go back to that. So the Riley's argument is, the parents is, she can only understand about 60% of the spoken language in the classroom. So let's put ourselves in the parents' shoes. And if they really believe this, that all this is good, I know she's making progress, but our child only understands 60%, then you understand why they continued with this suit. And they both have the same disability as their daughter, right? That's not something that should be lost on us here. So in this case, this independent examiner agreed with the school. Now they had some private interpreters that agreed with them, but they had one examiner that agreed with the school, and on appeal, the New York Commissioner of Education also agreed. Well, Raleigh said, okay. They then filed suit in U.S. District Court, which you have to do before it goes to the Supreme Court. Can't just go straight to the Supreme Court, right? All lawsuits have to work their way through the state system, and then appeal, and then you can go keep going up. So district court judge found that because Raleigh lacked an interpreter, she understands considerably less of what goes on, and so forth, than if she were not deaf. So the district judge agreed with the Raleighs and said she's not learning as much or performing as well as she would without her handicap. So finally got somebody to agree with him. They keep going. He concluded that she was not receiving FAPE and or an opportunity. So they won this battle. Not so fast. So they go to the school system goes to the Court of Appeals. Long story short, school district, the Court of Appeals agreed with the family and the district judge. So the school system says, no, not so fast. We're going to go to the Supreme Court. And here's what happened in Raleigh. Now I want you to notice something real important here. I'm looking at my time. So this was not a unanimous decision. That foreshadows what's going to happen the next 35 years. I'm surprised it took 35 years for another FAPE case to reach the Supreme Court. But 6 out of 9 agreed with the school system, and they said they provided FAPE, and but there were 3 dissenting remarks, and so that said, if you want to go back and read that, you'll see this was not a slam dunk. They won, and they said the school system had done what they needed to, and that they didn't. The parents didn't adequately explain what appropriate meant. Okay, so to sum that up, a free appropriate public education. Now from here going forward, I'm going to differentiate between educational benefit and the right to meet meaningful objectives in light of your personal circumstances. But in '82, the Supreme Court agreed with the school system, and that the other side had not explained what appropriate meant, and the law says that the child should benefit. Well, that's kind of an ambiguous word, right? I benefit from donuts with my coffee. I love donuts with my coffee, so I get great benefit from that. The only problem with that is, I can't measure it except when I grow out of my pants. So, and I have to get in a bigger size pants. But educational benefit, I would ask anybody listening today to tell me what that means. And then when you get down to an individual child, you have to talk about more than just benefit, right? But 35 years ago, that was the law, and they won. And these are the things that basically were the synopsis. So Amy was very different from Endrew, who we're about to talk about. I have this particular synopsis is in the references. You can look and go back and read this article. So Raleigh established some good things, but it didn't go far enough according to most attorneys and most parents. The 5th thing, you can read those things, but the 5th thing is again, the school district must provide access to special ed, that's good, which are individually designed, which is good, to provide benefit. Again, there we go again with benefit. What does that mean individually? They must provide personalized instruction with sufficient support. That's good. But the problem we kept having was, what is benefit educationally? In later years, the educational benefit standard was variously interpreted. So we spent 35 years trying to figure out exactly what FAPE meant for an individual child, right? And then the aftermath of Raleigh was some courts. This is the difference. This is what happened from '82 to 2016. Some courts understood the standard to require much more than trivial benefit, while others, and if you've been in those meetings, you're like, well, we don't have to offer that. Very dangerous thing to say in an IEP meeting. I always tell people in my career, the two most dangerous words as someone who works under special ed law is always and never. We've always done it that way, and we will never do that. And I personally know of 2 lawsuits that people were recorded saying that we will never do that. Okay, and what happened was what happened with Endrew. So fast forward, we're going to compare Endrew and Riley for the rest of the time here. So Endrew was in the 5th grade in Colorado. He was actually diagnosed at age 2. So he had, it was very obvious from his early development that Endrew had autism. And I kind of say that here. By the time Endrew reached 4th grade, his parents felt what? His progress had stalled, and his IEPs were basically the same from year to year. Going back to the previous screen, in the 5th grade, he really started having what? Behavioral problems. What was in Endrew's behavior plan? It was a big issue. And all these school psychologists out there, I'm sorry, we get hammered sometimes on this, but the behavior plan is what? The behavior plan is an extension of the IEP. Whether we like it or not, sometimes it is. And canned behavior plans that are similar to the last student can get you in a lot of trouble. It's a lot of work, a lot of time. But that was part of the problem on this case, is the parents did not feel like he was getting enough behavioral support. That was one of the things. Okay, so he was diagnosed at 2. Parents felt like 5 or 6 years in a row the IEPs were the same, and from year to year. Starting 5th grade, the parents offered another IEP that the parents thought was the same, and his academic and behavior performance improved after they pulled him out and put him in a private school in Denver. And a lot of you are going, well, yeah, I'm sure it does. They removed him from Summit and enrolled him in a specialized school for children with autism, Firefly Autism, $7,000 a year. And this was several years ago, so you can find them a lot, twice that expensive now. So let's stop just a second and think about what's happening here. In 35 years, we went from a FAPE to where they said it's you just got to do the minimum and kids got to benefit. Now we're pulling out a kid, put him in a private setting, and parents, you know what happens next, right? And we're going to compare what happens in this private alternative school to what happened in the public school. So kid does better, parents go, I think you should reimburse us. You didn't offer FAPE. We had to go somewhere else to get FAPE. And you didn't fulfill IDEA. Plus, the first thing, your first reaction is not going to be, yeah, let's just write the $7,000 check. Go tell your superintendent that. I need a $7,000 check for one student, and I'll let you know. He's in the 5th grade. We got 7 years of this. So they said no, of course, and that they were meeting FAPE. And their argument, if you go back and look at the docket, was basically the Raleigh standard says we don't have to do that. Now, understand Raleigh's still on the books, and it can still be used in cases. Then, of course, they went the same as Raleigh. They went up to the district court. They lost their case before the U.S. District Court, Colorado. The argument was that the federal statute only requires that schools provide some educational benefit. What does that sound like? That sounds like Raleigh. So it looks like in this case, they're arguing that Raleigh's not enough. And indeed, they were right. And they won. And we'll talk about why they won. So after the district court, let me go back to that. Yeah. For the Solicitor General, there were a lot of people involved in this case that got it pushed to the Supreme Court. People have been waiting for a case like this, another FAPE case to clarify it, and Endrew was that case. And there are a lot of people encouraged the Supreme Court to take it. They did. And without going into great detail, you can read it, but basically it was a 16-page decision by the Supreme Court. They started hearing it in 16, and when they finished, there was a 16-page decision. And the court held it to meet its substantive obligation under special ed law. School must offer an IEP. This is very important. Reasonably calculated to make progress appropriate in light of the child's circumstances. Now, we're not comparing you to a standard. If I say I'm the child's circumstances, I'm comparing you to who? Not necessarily the other kids in the class, but to yourself. Groundbreaking. That's the first big thing that came out of it. We don't want you just to have benefit. What does this child need? That's what they were saying, right? In clarifying the standard, the court rejected the merely more than diminished, more than trivial standard applied by the 10th Circuit. 10th Circuit covers Colorado and a couple other states. In determining the scope of fate. Now, this was unanimous. Not only did they disagree with the circuit court, all 9 justices agreed. The court reinforced the requirement, and this is the big change, that every child should have the chance to meet challenging objectives. Does that sound like an IEP term to you? Absolutely. Short-term objectives, which feed into what? Long-term goals. They got down to the brass tacks here, right? You got to write an IEP now for an individual kid that considers his or her circumstances and it has challenging objectives. Now, I can measure objectives, right? I can't always measure benefit by itself. They changed the language to where merely more than trivial. So we can't go along and say anymore that we don't have to offer this or we don't have to offer that. On an individual case, you might have to. And service animals are an example. Different types of ESL are an example of things in people's mind that we don't have to do that. In my job, the last 5 years before I retired, I was people appraiser coordinator. And one of my jobs was doing the training for new special ed law and dear colleague letters that came down. How many of you thought when you went into your career, you would be pulled into IEPs for kids that are transgender or bullying? And all those are required by the Department of Justice now. So why did Endrew win? He prevailed in this case and his parents because he made significantly more progress. This might be the most important stream in his alternative school than while regressing in the previous public school. That, although is an inverse correlation, right? It was loud to the Supreme Court. Okay. It was so stark to them that they said this progress demonstrated, look at this. This is the actual language from the docket, the behavior intervention plan. And through his private school's ability to do what? Track his progress with data collection and analysis tools. All you school psychologists and eds out there, we know we always brag at our conferences. I love to go to them and show me the data, right? Well, if we don't watch it, we'll write a behavior plan. It's very hard to measure. It's difficult. The best behavior plans are written by everybody that works for the kid. As a psychologist, I'm the architect. That's the best ones I've ever written. Does it take longer? Absolutely. But you also don't have to go back and adjust them if it's written with good quality collection or the ability to collect data on what's in the behavior plan. It's a big deal in this case because his behavior is what created a lot of problems. We all know what happened. There was lots of meetings. There was lots of behavior plans. And you can go back and read it. This was a 16-page decision, unanimous. So in '82, Rowley was the standard through 2017. Endrew did not necessarily replace Rowley. This is important, as the students' placements were significantly different. It did expand a higher standard. So let's discuss the last few screens I have. I'm going to say the same thing a couple times. Why? Because I was a teacher at the university level for 25 years, and I've learned that You got to take the complex and make it simple. So this last few screens will hammer the difference between benefit and objectives. And that's really what changed. So we're about to review everything we just talked about. Now I want to wrap it up. But make no mistake, you never know if you're going to be that person on a case that ends up in district court and a circuit court, or could go to the Supreme Court. Never know. So the Raleigh court charted a middle path. This was from Raleigh and Endrew to provide an IEP that was reasonably calculated to enable the child to receive benefit. That's from the exact language. There we go again. Supreme Court determined that appropriate education means states only had to provide some educational benefit. Again, I know I'm hammering this, but how do you measure that unless you have really clear objectives, right? And that's the big problem we have with behavior plans and IEPs, is agreeing on it first, and can I measure it? And look at the last part of this. What they were doing in Raleigh, and what we've done for years, is are kids meeting grade level expectations? So the question I'm going to ask you there is that enough for kids with disabilities? Just to say I'm meeting grade level expectations. Amy Raleigh was meeting grade level expectations, and her parents felt like she needed more. She ended up graduating and actually has a PhD. And the reason that the school system won in Raleigh was because they did write good objectives. They did offer other services. They did show progress. What's the big change? I'm reiterating, and the court restated Raleigh's general principle in Endrew. They didn't do away with it, that you have to write an IEP reasonably calculated to make progress and appropriate in light of the student's particular circumstances. For some students, like Amy Raleigh, keeping pace with their non-disabled peers and advancing from grade to grade may be appropriate. It seemed to be with her. But for students like Endrew, who are in programs substantially or completely separate from their peers, the student's own potential, that might be the most important thing I've said. Here's where they shifted. I'm not necessarily comparing you to other students. I'm comparing you to what you need given your disability. Wow, that's big. What is appropriate in light of the student's circumstances? So we're getting there. For these students, the educational program must be appropriately ambitious. They went back and said again, not just benefit, but they must be provided the chance to meet what challenging objectives, meaning things much higher than they're functioning right now, put it in our language. We have to write objectives that they can strive for, that they can improve. The only way they can meet those objectives is what? Improve their language, their social skills, their math ability, things that we can measure. Okay, so basically the last couple of screens, what's the comparison? To leave you with the last thought. Most people believe, even most attorneys now, that the IEP was adequate under Raleigh. It provided a basic benefit, and we all know what that means. And I've already said this, but so I like to do the benefit versus objectives. Benefit versus objectives. That's what Raleigh changed. It did two things. Endrew changed. It shifted from saying, we just got to do a basic IEP, compare you to other kids too. Number one, I'm going to compare your performance to your own performance last year. And number two, I want objectives higher than the kids functioning right now. So they have to improve to meet them. All right, I'm about to wrap it up here. I would recommend both of these websites. Howard Doff knows more about this asleep than I do awake. I've learned so much from reading from him. He's a great speaker if you've been able to hear him. He's got a blog about Endrew and Raleigh that really is helpful. And the Improving Our Schools blog spot is a new article that talks about how we're trying to write IEPs and meet kids' needs in the midst of this pandemic and this the pandemic of the century that's affecting how we do all education, but particularly how do we write IEPs now and do them virtually sometimes and meet the specific needs of these children with disabilities. All right, Amber told me we gotta move on to the next one, and I'm getting to the end here. And it's the basic references that I use for this particular area. And a lot of it is in the, you can read all this stuff in the Federal Register if you're a law nerd like I am. I have found that getting legal training really frames the way you participate in IEP meetings, understanding what the federal law says. And sometimes it's going to be in conflict, and as a provider or a parent or advocate, you have to understand that if it gets down to a disagreement and it goes to the administrative law judge, they're going to look at federal law first, and they're going to compare it. And that's what happened in both of these cases. They actually rewrote federal law, right? Okay. Amber said I could do this, so I do have a consulting business where I train school systems, principals, teachers. I even have one I do for paraprofessionals. I think it's extremely important for kids on the spectrum. It's my card. I'm here. I've been enjoying the training, so I'm very honored to be able to speak to you today. This is a very educated and informed crowd, and I've had a great time going through this. I hope that it was helpful to you. And these are my contacts information if you need to get in touch with me. So thank you for having me today. And I learned even more going through this again and presenting it. Teacher always learns the most, right? All right, thank you. And I'll be listening in to the other great panelists today. Thank you.
Flint, can you hear me?
I can.
Hey, we got a couple questions from the audience.
Okay.
The first one is, how can a parent determine if an IEP is providing FAPE in light of not being able to monitor what's happening in the classroom? For example, if you have a nonverbal or minimally communicated child who can't relate accurately what's happening in the classroom, how would a parent know that their child is or is not getting FAPE?
Wow, but that's a great question. And I think part of that's what led to these two lawsuits. I want to go back real quick to the foundational principles if I can get to them. And that would fall in number 7, right? And so this is where you have to think outside the box, and individualization really is important. That's where the parent and the teacher have to sit down and go, we got to have a different communication process for my child here. This is a collaboration issue to me. It may not be spelled out in the IEP, but it falls under number 7 of the foundational principles. That parent definitely has to know what's going on in that classroom. And that's why there was some legislation, was it last year, Amber, or the year before, where they were wanting to put cameras in the special ed classroom, right?
That actually they've tried that past couple of years. There's been different legislation proposed to put cameras in the classroom, and I think with the cost and things like that, it just hasn't, it's made it through some of the hoops, but not all of them.
But the reason people want to do it is because of this question right here, right? They want it, some parents want to see what's going on in the classroom and be able, because their child can't communicate. Since we don't have that, I think the parent and the teacher have to develop something that could be part of the behavior plan. If the child needs it, it needs to be documented. How am I going to know how my child's doing in your classroom? And that's going to be more than just report cards and a phone call every now and then. It needs to be more formal. I've helped teachers do it several times.
So the next question is, our school would only write a behavior plan for a problem student. They didn't consider a plan necessary for every student with autism, even if the student was being punitively treated for the symptoms of the disorder. Would that, I think what the person asking is, would that be a violation potentially of FAPE if they are being punished for behaviors related to their disability, and it's keeping them from accessing the least restrictive environment or educational opportunities? Would that play into what you're speaking about today?
I think, yeah, I think it could, depending on the case. That's why when you write your behavior plans, you have to be able to collect data on them. You have to write behavioral interventions that are measurable. Is that easy? No. But if you have a behavior plan, it is part of the IEP, and if it's not working, you have to go back to the drawing board, to be honest with you. And I've had to do that several times in my career and go, well, that didn't work. It looked good. The research said it would work. But that behavior intervention plan is so important, written in light of the research for kids on the spectrum. So if the child needs a behavior plan and they don't have one, there's been many cases where the administrative law judge says, why is it there a behavior plan? And if it is, why is it not being implemented the way it was written? So it could be. It could be.
Okay. Well, Flint, I want to thank you for joining us today and volunteering your time to speak with us today. This is a really important topic, and I'm hoping that everybody gained a lot from it and are going to be better equipped to go into those IEP meetings. If you would, I do want to give him one more plug. Flint has conducted, he probably cannot count how many trainings over the years throughout his career. He speaks on school-based mental health, crisis prevention and response, special education, civil rights regulation, autism interventions, and other topics for school administrators, school teachers, really at all levels of the district, and also for your professional organizations as well. So if you would like to get in touch with him, he is, we're all jealous because he is recently retired and living the good life. And free to come train in your district. So Flint, if you'd like, in the chat box, if you want to put your email address in there one more time so that people can reach out to you if they'd like to follow up or book you for a training. And we're going to stop the recording briefly, but Zoom will continue. We're going to stop the recording right now. Kristen, if you can hit that stop button. And then we will have a few minutes to transition into our next speaker. And I'm going to turn it over to Miss Dorothy Parks, who's going to introduce our next speaker.
Thanks a lot. See you later.
Thank you, Flint.
Okay, bye-bye.
Bear with us just one moment.